Next case is cause number 325-709, cause number 325-707. Both cases are styled the state of Texas versus Clay Elwood Autry III. Mr. Autry is appearing via Zoom. Mr. Autry is represented by attorney Adam Crawshaw. Attorney Adam Crawshaw is also appearing via Zoom. Mr. Autry, you could take your mic off of mute. Mr. Autry.
Yes, sir. Thank you. How you doing, Judge?
I'm doing fine. Thanks for asking. Mr. Autry, you're here represented by your attorney, attorney Adam Crawshaw. Attorney Crawshaw, how are you doing?
Doing well, Judge. Thank you.
Okay. Attorney Crawshaw, what's your announcement in Mr. Autry's case?
Judge, we still have motion to suppress on file. I didn't speak with the ADA assigned to this case. I was going to double check if that's changed.
The ADA has changed, I guess, since the last time you were here.
Who's the ADA in charge of the case now?
Tommy. Oh, it's Tommy Coleman. You probably can see him on the monitor next to.
I can.
Okay.
Happy to discuss the case with the judge.
Okay, so you need to get with Mr. Coleman.
Yes, please, Your Honor.
Okay, so we'll reset your case to give you an opportunity to talk to Mr. Coleman. How much time do you need?
Just a 30-day reset, Judge, and then we can move the case into, the remaining contested motions and whatnot if we need to.
Okay, what's that date? Okay, this case is going to be reset to June 27th, 2022. Is that fine with your schedule?
Can we go to either, can we go to, July 4th is a holiday, never mind.
What about July 11th?
Yes, sir, that'll be fine.
Okay, this case is going to be reset to July 11th, 2022. Mr. Crawshaw, your reset will be sent to you, and Mr. Autry, stay in contact with your attorney. Your attorney will give you your reset. Your reset date is July 11th of 2022 for both cases. Mr. Crawshaw, you're free to go. You have a blessed day. And Mr. Autry, you're free to go as well, and you have a blessed day.
Thank you, Judge.
You're welcome.
Thank you, Judge.
You're welcome. Caleb Quinn, Mr. Bailey, he's on the pre-trial conference docket. This was one of Mr. Macon's cases.
Your Honor, that'll be a plea later this morning with Mr. Vasquez.
Oh, okay, Mr. Vasquez just stepped in. Okay, so that'll be a plea. Okay, Mr. Quinn, you can have a seat. And then once Mr. Vasquez do the paperwork, we'll call you back on up. Thank you. Franklin Golick.
Your Honor, that's going to be a plea.
It'd be a plea as well.
Yes, Your
You
Honor.
can have him come on in.
Not today, but at another date.
Oh, okay, just have him come on in then. Okay. Mr. Golick, you can come on up. And Mr. Bailey, if you can get Joshua Peavy as well. Yeah. This is cause number 330184. Case of style of state of Texas versus Franklin Derek Golick.
Yes.
Mr. Golick, how are you doing?
Good, sir. How are you?
I'm doing fine. Mr. Golick, you're here represented by your attorney who's appearing via Zoom, Mr. James Macon. Mr. Macon, how are you doing?
I'm doing good this morning, Your Honor. Thank you.
Okay, and the state is represented by attorney Tommy Coleman. Attorney Coleman, how are you doing?
Good, Your Honor.
Mr. Macon, what is your announcement in Mr. Golick's case?
Your Honor, if that could be reset for a plea, we'll arrive at a position of the case.
Okay, give us a plea date. You want a standard reset?
Yes, Your Honor.
Okay. Okay, it's gonna be reset to June 27th of 2022. Mr. Golick, your attorney is gonna get a copy of the reset sent to him. You can get your reset, stand on the far end in front of our coordinator. Once you get the reset, you'll be free to go and you have a blessed day.
Yes, sir. Thank you.
All right, on the far end on the X. Joshua Peavy. This is cause number 331268, case is filed in the state of Texas versus Joshua Shea Peavy. Mr. Peavy, is that your full name?
Yes, sir.
How you doing, Mr. Peavy?
Sir.
How are you doing?
I'm good.
That's good. Now, Mr. Peavy, you're represented by your attorney, Mr. James Macon, who is appearing via Zoom. Mr. Macon, what is your announcement in Mr. Peavy's case?
Your Honor, Mr. Vasquez is going to get with Mr. Peavy this morning, and it will be a plea.
Okay, Mr. Peavy, you could just have a seat in one of the chairs that have the black and yellow tape in the gallery. Jason Chandler. I'm still on the announcement. Jason Chandler, page 2, the third case down.
Your Honor, on Mr. Chandler, that's also going to be a plea handled by Mr. Vasquez this morning.
Okay, Mrs. Chandler,
Yes, sir.
have you come forward? Your attorney is Mr. James Macon. He's appearing on Zoom.
Yes, sir.
He announced to the court that that bill plea be handled by attorney Joel Vasquez. You can have a seat in one of the chairs that have the black and yellow tape in the gallery.
Yes, sir.
Right. Okay, Mr. Macon, I think that's the last case that you have. Is that correct?
Your Honor, I have Mr. Kyle Franklin. It's an announcement, and that's also going to be a plea at the next resetting.
Hold on, you say Franklin?
Yes, Kyle Franklin. He's zooming in right there.
Oh, he's on Zoom. Okay. Okay. This is cause number 326702. Case is style of state of Texas versus Kyle Morgan Franklin. Mr. Franklin, you can take your mic off of mute. Mr. Franklin, how are you doing?
I'm doing well, Judge. Thanks for asking.
That's good. And Mr. Macon, how much time do you need for the reset on a plea in this case?
Just when you set the other case earlier, that'll be fine,
Was
Your
it
Honor.
June
June.
Okay, it'd be June 27th. Mr. Franklin, your case is reset to June 27th for plea. Now, Mr. Franklin, your attorney and your bondsman will be given copies of the reset. Stay in contact with your attorney and your bondsman. This will conclude your case. You're free to go and you have a blessed day.
Have a blessed day as well, Judge. Thank you.
You're welcome. And Mr. Macon, I think this is your last case, so you're free to go as well and you have a blessed day.
Yes, Your Honor. Thank you very much. You have a
you
good
welcome.
day.
All right, thank you. I'm still on announcement docket. Mr. Paget, is
Your Honor.
Ronald Kennedy, is he in drug court? I see he has a drug court
He
case.
is in drug court, Your Honor.
Okay,
Uh,
okay, we'll come.
I'm going to be running down there. He'll be in drug court first, and we'll bring him back. to you.
Okay, let's, you have any other cases?
I do, Your Honor. I have
You have
three cases on your trial docket and one on your pre-trial conference. docket.
yeah, Francis Morrell,
Ms. Morrell is in the anger management program. It's Ms. Nelson's case.
is she here?
She's not here. She'll, I mean, she might.
She gonna appear?
Well,
Okay,
I'm gonna get her on Zoom because, you know, they put her in the program.
Okay.
She's doing everything in Houston, and that's where she lives.
okay,
So we're,
okay.
we'll get up on-
So we'll
on Zoom.
get her on Zoom in a little bit. Okay, let's see. And you said on the trial,
I have three cases on your trial docket, Your Honor.
oh, where's the
Should be
pen?
here, and
Hold
We're
on.
ready to make announcements on all of them.
Okay, we're gonna need, Mr. Paget's cases on the trial docket. We have Daniel Martinez, Christopher Herring, Kevin Jefferson. All three on the trial docket. Attorney James Paget.
That's gonna be a bench trial. I think it's- Is it yours? I think it's Tony's, isn't it?
Yeah, it is.
Okay.
Martinez's.
I think that's all. Yeah. I think the other ones are Tony's. But maybe not. Take a peek and see. I have Martinez is Tony's. Okay, there's one. Is it yours?
No, Tony's.
Okay. Tony's.
Is that Martinez?
This is Martinez. Good morning, Mr. Martinez.
Court is in session and calls number 328234. Case is style of State of Texas versus Daniel Antonio Martinez. Mr. Martinez, is that your full name? How are you doing, Mr. Martinez?
Good, how you doing?
I'm doing fine, thanks for asking. Mr. Martinez, your attorney is Attorney James Paget. Attorney Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning. Mr. Paget, what's your announcement in Mr. Martinez's case?
We're entering a plea of re-urge and not guilty, and we're ready at this time, Your Honor.
Your Honor, I confer with defense counsel, and we have both elected to waive our right to a jury trial. We'd like to proceed with the bench trial this morning. Your Honor.
Okay,
That is accurate, Your Honor.
okay, Mr. Coleman. Okay, so both the state and the defense is waiving the right to a jury trial.
That's right.
So, Mr. Coleman, would you like to read the information?
Yes, sir. In the name and by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Daniel Antonio Martinez, hereinafter styled a defendant heretofore on or about November the 11th, 2020, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Alejandra Dognies, Dognies, hereinafter styled the complainant by Alejandro Goodnees, Godines, and at the time of said assault, complainant was a person with whom the defendant has had a dating relationship against the peace and dignity of the state.
Mr. Martinez, how do you plead? Not guilty, guilty, or no contest?
Not here.
Okay. State, would you like to make an opening statement?
State waives this opening statement now.
Defense, you like to make an opening statement?
We will waive our opening statement, Your Honor.
State, you can call your first witness.
State calls Alejandra Goodines, Godines.
Is that Godinez?
Godines. I apologize.
State, do you have any other witnesses?
State has no further witnesses, Your Honor. State would rest.
Defense,
Your Honor, at this time, we would move for an instructed verdict and ask that the defendant be found not guilty by the court.
okay, that motion will be granted. Mr. Gardinas, you've been acquitted. That simply means you've been found not guilty of these charges. The court has granted instructed verdict. Mr. Gardinas, we should have a judgment in a little bit. How long you on, Bridget, to do that instructed verdict? You already have it? Okay. Okay, you stand right there. You can get your instructed verdict. Once you get the instructed verdict, you'll be free to go and you have a blessed day.
The other is quiet. Inside the courtroom.
Okay, Christopher Herring. Court is in session and calls numbers 328-920 and calls number 331-570. Both cases are styled of State of Texas versus Christopher Herring. Mr. Herring, is that your full name?
Yes, sir. Christopher Michael Hand.
Christopher Michael Herring. Okay, Mr. Herring, how are you doing?
Blessed in yourself, sir.
I'm blessed as well. Mr. Herring, you're represented here by your attorney, James Paget. Attorney Paget, how are you doing?
Doing well, Your Honor.
Okay, Mr. Paget, what's your announcement?
Your Honor, when we were in court last time, we discovered that Mr. Herring had a second case that I was not hired on.
Oh, okay.
Since that time, on 4/24, I filed a letter of representation, electronically filed it. I'm now attached to the case. Over the past week, Mr. Coleman and I have been in negotiation. He's relayed an acceptable offer to me. So if you would take this case off your trial docket, put it on a plea docket, the state is going to be dismissing one of the cases and we're going to be entering a plea on the other. one.
Okay, how much time do you
Just
need?
a regular reset.
Standard reset?
Standard reset.
Okay, Mr. Herring, both of these cases will be reset to June 27th, 2022 for a plea. Mr. Herring, your attorney is going to get you signed for your reset. Once you get your reset, you'll be free to go and you have a blessed
Hello?
Yes, would you, okay, the person that's on Zoom, last three numbers are 549. Would you please state your name?
Lionel Matthews.
Okay, Mr. Matthews, please put your mic on mute, and then when we call your case, you can take it off from mute.
Yes, sir.
Yes, yes.
And the same thing, I received your offer. Okay, that's right. You made it up. Gotcha.
This is cause number 331028. Case is style of State of Texas versus Kevin Jamel Jefferson. Is that correct?
Yes, sir.
Mr. Jefferson, how are you doing?
Well, now, how about yourself?
I'm doing fine. Thanks for asking. Mr. Jefferson, you're here represented by your attorney James Paget. Attorney Paget, what's your announcement in Mr. Jefferson's case?
Your Honor, a similar announcement here. Mr. Coleman and I have been in negotiations. We had another issue we were dealing with, but now that we've taken care of that issue, he's going to email me an offer on the case. I'm certain this case can be taken care of if you will give us a standard reset on it.
You want it on the plea docket or?
That's correct.
Okay, give us, is that, okay, it's gonna be reset to June 27th of 2022. Mr. Paget, you can sign for your reset. Once you get your reset from your attorney, Mr. Jefferson, you'll be free to go and you have a blessed day.
Thank you, son.
And Mr. Paget, I think this is your last case? Well, I think he had one more. That's right, you're gonna get somebody on Zoom.
She's on Zoom.
No, that gentleman is Matthews, that's someone else.
Okay, well then.
Yeah, and I
we'll
think you
step
have to go
away,
to
Your
drug
Honor,
court
and
on
then
another case too, right?
We'll come back up at the appropriate
Okay.
time when she gets on Zoom.
Okay, that's fine. Is Christy Gans present? Okay. Mr. Reynolds?
Yes, Judge.
Bailiff just called the name of Christy Gans.
Yes.
She's not present. Is that, somebody's coming on Zoom right now. I don't know who that is.
That's Ms. Morel.
Oh, that's somebody else. Okay. So Christy Gans is not present at the moment. We'll recall the case once we go back through the docket.
Okay, Judge, I wanted to let the court know that this is, well, I mean, this is on a trial docket, but I've got a
Right.
vacation. I have a vacation starting tomorrow, so I would be unable to try the case.
That's fine. That's fine. But just see if you can get Ms. Gans to make an appearance.
Okay, let me see if I can find her. Thank you, Judge.
All right. You're welcome. And
Okay.
Is it possible to go ahead and do this?
Yeah.
That way I can
Hold
go
on.
down to drug court and get Mr. Kennedy back down here. She's on your pretrial conference docket, Your Honor, Francis Morel. And it's Ms. Nelson's case.
Okay. Okay, this is cause number 326534. Case is style of State of Texas versus Francis Morel. Ms. Morel, how are you doing?
Just fine.
That's good. Ms. Morel, you're here represented by your attorney, Attorney James Padgett. Attorney Padgett, what is your announcement in Ms. Morel's case?
Ms. Morel is currently in the anger management program, Your Honor, so I've looked at the state's file. I don't see any notes with problems with the program. As far as we know, she's doing well in the program. This is our second appearance here while she's been in the program. Ms. Morel, is everything going okay in the program?
Yes, it is. I have 2 more sessions left. I've been going 3 days a week.
Well,
So we can just a standard 30-day
I would,
reset?
you know, Your
She
Honor,
said 2 more sessions.
2 more sessions. Well, if whatever pleases
That's
the
like,
court.
she can do that. She's doing that in maybe 1 or 2 weeks.
Like I said, whatever
Wow.
pleases the court. As long as
Okay,
we get it done.
so Ms. Morel, do you think you'll be able to wrap up those 2 sessions within a month?
Oh, yes, sir.
Okay, let's give a standard 30-day reset. Okay, it's gonna be reset to June 27th of 2022. Ms. Morel, stay in contact with your attorney and your bondsman. This will conclude your case. You're free to go, and you have a blessed day.
You have a blessed day too.
Okay. And Mr., you can go to drug court. Okay.
Thank you. Sure.
Oh, I need it.
Thank you.
Destiny Lachelle Lewis. Court is in session in 2 cases. First case is cause number 321500. Second case is cause number 330298. Both cases are style of State of Texas versus Destiny Lachelle Lewis. Ms. Lewis, is that your full name?
Yes, sir.
How you doing, Ms. Lewis?
I'm good, thanks for asking. How about yourself?
I'm doing fine. Thanks for asking. Ms. Lewis, you're here represented by your attorney, John West. Attorney West, how are you doing?
Good, Your Honor. Thank you.
Mr. West, what is your announcement, Ms.?
Your Honor, we have discovered, we have an offer. I need to go over everything with my client. We've already set up a date in a couple of weeks for her to come in and look at everything to make a decision. So we're requesting our appointments for 2 weeks from now. So at least I'd say 30 days, if we get 30 days.
Do you need 30 or 45? Which one you think will be better?
Depending on when 30 falls, I'll get with them out.
27 or 7/11?
We look at my calendar, 'cause I know I got some vacations coming up, so. What was the 2 dates ago?
6/27
Okay.
on July 11th.
And that's fine with the state, Your Honor.
Okay, you are.
Actually, I have a bunch of stuff on the 11th, so let's do 27.
Okay. Ms. Lewis, your cases will be reset to June 27 of 2022. Your attorney will sign for your recess. Once you get your recess from your attorney, you'll be free to go and you have a blessed day.
Yes, sir. Thank you.
You're welcome. Okay.
Okay. 10 o'clock. Thank you.
Anthony Woodcock. I'm on the announcement docket, the bottom of page 1 and the top of page 2. Court is in session in 4 cases. All 4 cases are filed the state of Texas versus Anthony Craig Woodcock. First case is cause number 328-124. Second case is cause number 328-126. Third case is cause number 328-128. And the fourth case is cause number 328-194. All 4 cases are filed the state of Texas versus Anthony Craig Woodcock. Mr. Woodcock, is that your full name?
Yes, sir.
How you doing, Mr. Woodcock?
Good, how are you?
I'm doing fine. Thanks, Max. Mr. Woodcock, you represented here by your attorney, Charles Rojas. Attorney Rojas, how are you doing?
Doing well, Judge.
Attorney Rojas, what's your announcement in Mr. Woodcock's cases?
Judge, we're gonna ask for another announcement document. I need time to go over the discovery with Mr. Woodcock.
Okay, how much time do you need?
If we get about 45 days.
Okay, give us 45 days. Okay, Mr. Woodcock, your cases will be reset to July 18th of 2022. Mr. Woodcock, your attorney will be given notice of your resets. Stay in contact with your attorney and your Boswell. Mr. Woodcock, Mr. Rojas, would you please sign for his recess? Once you get your reset, you'll be free to go and you have a blessed day.
Thank you. Okay, 2 more. Judge.
I know. Ridley McKinley. He's on the last one on the announcement docket. Ridley McKinney. This is cause number 331634. Case is filed in the state of Texas versus Ridley Gerard McKinley the third.
Yes, sir.
Mr. McKinley, is that your full name?
Yes, sir.
How you doing, Mr. McKinley?
I'm doing all right. How about you?
I'm doing fine. Thanks for asking. Mr. McKinley, you're here represented by your attorney, Charles Rojas. Attorney Rojas, what's your announcement in Mr. McKinley's case?
Mr. McKinley has a felony that was set this morning. That felony's already been reset, Judge. We're asking it to be reset along with the felony.
Do we have a date?
You have a date?
They haven't given me the date yet.
That looks like it's gonna be June 20th.
Okay. We will reset it the same date of the felony. It says June 20th. Okay, Mr. Rojas, you can sign for Mr. McKinley's reset. Mr. McKinley, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Yes, sir.
Our next case is on Zoom. This is cause number 321-999. Case is style of State of Texas versus Lionel Matthews. Mr. Matthews, you can take your mic off of mute.
Yes, sir.
Okay, Mr. Matthews, how are you doing?
I'm in pain, but I'm okay.
Okay, we hope that you recover from your pain. Mr. Matthews, you're here represented by your attorney, Mr. Charles Rojas. Mr. Rojas, well, what's your announcement in Mr. Matthews' case?
Mr. Matthews had a car accident about a week ago, Judge, and he's currently under a doctor's care. He lives in Mississippi. He cannot travel. We're asking for a reset.
How much time?
It's on the trial docket. It's a regular trial reset, and we'll see. Actually, Judge, since he lives in Mississippi, we would like to get a date where we're.
Okay, let's reset it for 90 days.
Okay.
August 23rd.
Okay, we're gonna reset August 23rd. Okay, Mr. Rojas, you can get your reset, sign for your reset. Mr. Matthews, your attorney will be given a copy of your reset as well as your bondsman. Stay in contact with your attorney and your bondsman. Your case has been reset for trial August 23rd of 2022. We hope that you have a speedy recovery. This will conclude your case and you have a blessed day.
You do the same. Thank you, sir. Can I hang up now?
Yes, you're free to go.
Thank you.
Who we have ready, Davis? Ooh. Oh.
Never mind.
Why would he sign him unless he's over there? No. Nicholas Davis.
Good morning, y'all.
Good morning.
How long you got your job? 2 weeks? Yes.
Court is in session. Court is in session in cause number 330-999, 126. Case is style of State of Texas versus Nicholas Caleb Davies. Mr. Davies, is that your full name?
Yes, sir.
Mr. Davies, would you please raise your right hand? Mr. Davies, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Davies, you may put your hand down. How are you doing, Mr. Davies?
I'm all right.
That's good. Mr. Davies, you're here represented by your attorney, Attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
Attorney Lawrence, do you waive a record in Mr. Davies' case?
Yes, we do, Your Honor.
Mr. Davies, then cause number 330126, I have before me a document that is titled Information. This information has been filed by the Jefferson County District Attorney's Office. This information alleges that on or about June 5th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault family violence. Mr. Davies, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Davies, how do you plead? Guilty,
Please-
not
please no
guilty, or no
contest.
contest? You say no contest?
Yes, sir.
Now, Mr. Davies, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Davis, I have before me another document. This document is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of the same document, Mr. Davis, there's a set of initials ND on a line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes.
On the third page of the same document, Mr. Davies, there's a signature above the line that's titled Defendant. Is that your signature?
Yes.
And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, there's a signature at the bottom of this document above the line that is titled Defendant. Is this your signature?
Yes, sir.
There's one box that's checked at the top of this document. That box that's checked states that this is a plea bargain agreement and you have no right of appeal. Do you understand that?
Yes.
Mr. Davis, did you sign another document on paper that's titled Discovery Certification?
Yes.
Let me see it. Okay, now, Mr. Davis, is this your signature on the line that's titled Defendant
Yes, sir.
of the Discovery Certification? Now, Mr. Davis, before you signed and initialed all of these documents that I've just mentioned, did your attorney, Mr. Lawrence, go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, you like to offer State's Exhibit number 1 and State's Exhibit number 2,
Yes,
the
Your Honor.
probable cause affidavit.
Yes, Your Honor.
Any objections, Mr. Lawrence?
None, Your Honor.
Okay, no objection. State's Exhibits 1 and 2 are admitted. Mr. Davis, are you a citizen of the United States?
Yes, sir.
Mr. Lawrence, you've advised and counseled Mr. Davis. Is there any evidence that he is currently mentally incompetent to stand trial?
Oh, none at all, Your Honor.
Mr. Davis, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Davis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do you have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
90 days prorated for 6 months, $500 fine, 30 hours community service requirement, and bill.
Okay, Mr. Davis, the state is offering that you serve 90 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for 6 months. During the 6 months probationary period, you'll be required to pay a fine of $500 plus court costs of $352. The total fine and court cost is $852. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, You'll also be required to pay a court-appointed attorney's fees of $250. Now, your total monthly installments, Mr. Davis, is $295. Will you be able to pay the $295?
Yes.
You'll
Your Honor,
also be required.
Let me kind of explain something. He's been without work for a couple of years until about 2 weeks ago, when he started working for Leslie Pools, and he's now making an income. He also has 3 fairly young children. We were hoping that the probation fee could be reduced to about $35 a month. Judge Flores used to do that for us, and without having to find him indigent. He is largely indigent at present. He just got a job. So I was just hoping we could keep the probation fees down so he could help support his children, most of whom are in school now.
Okay, well, Mr. Davis, I asked, would you be able to pay the $295 per month? You stated that you'll be able to pay it. Is that correct?
Yes.
Okay. So now you'll also be required to perform 30 hours of community service. You'll also be required to pay the $100 fee to a family violence center in Jefferson County. And you'll be required to attend the BIP program as a condition of your probation. You will also be required to adhere to the other standard terms and conditions of your probation. Do you understand the state's offer?
Yes.
Do you think that the state's offer is fair and just?
Yes.
And do you accept the state's offer? Okay, Mr. Davis, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Davis, you're going to stand on the X next to your attorney, and you're going to follow the directions of the clerk. And once you finish following her directions, you'll be free to go. Well, I have one more item. Mr. Davis, would you please stand back here? Also, Mr. Davis, this is a assault family violence case, and pursuant to Texas Administrative Code Section 176.1, the court hereby admonish you of the following. Number 1, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number 2, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number 3, under Texas Penal Code Section 46.013A, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is 1, an antique or curio firearm manufactured before 1899, or 2, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Order of Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, Unlawful carrying weapons. Penal Code Section 46.04, Unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Now, Mr. Davies, I'm going to give a copy of this to you. That's for your records. You're going to stand on the X next to your attorney. You're going to follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. And Mr. Lawrence, I think this is your last case.
Pardon, Your Honor?
Is this your last case? Do you
Yes,
have-
Your Honor.
Okay, so once you finish signing, you'll be free to go, and you have a blessed day as well.
Thank you, Your Honor.
You're welcome.
Mr. Lawrence? Mr. Lawrence? You can sign.
Ms. Ferrazzo,
Yes, sir.
Brandon Andre Richards. It's on the trial docket.
Yes, everything.
This is cause number 330482. Case is out of the state of Texas versus Brandon Andre Richards.
Yes, sir.
That's your full name?
Yes, sir.
Okay, how you doing, Mr. Richards?
All right.
Okay. Mr. Richards, you're here represented by your attorney, Miss Lori Ferrazzo. Ms. Ferrazzo, how are you doing?
I'm doing well, Your Honor. Thank you.
Okay, now, Miss Prosecutor, attorney, right? That's your case?
Well, that's what I was just looking at. I just noticed that
That's,
it does say bench trial.
yeah, I noticed that too.
Yes.
Okay, let me check and see. If you could enlighten me.
Okay, well, so basically, the complaining witness, doesn't want to cooperate. They prefer all together, they.
Did,
Yeah, Your Honor, if you could look at the notes, I'll take care of it in just a second.
okay, just, y'all can just have a seat.
Okay.
We'll call y'all back up. Prosecutor.
This should be pretty.
Brandon Andre Richards. This is cause number 330482. Case of South State of Texas versus Brandon Andre Richards. And Mr. Richards, that's your full name?
Yes, sir.
Okay. State, are you ready?
State's ready.
Defense, you ready?
Ready.
We're going, now, defense, well, state, are you waiving
The state will waive a record.
and are you waiving jury trial as well?
I'm
Are
sorry.
you waiving the jury trial?
Yes, Your Honor.
And state, I mean, a defense, you waiving the jury trial?
Yes, Your
And you
Honor.
also waiving a record?
Yes, Your Honor.
Okay. Okay, at this time, Mr. Sherry, would you like to read the information?
Yes, Your Honor. This is cause number 330482, State of Texas versus Brandon Andre Richards. In and by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney in Jefferson County, Texas, on behalf of the state of Texas and presents into the County Court of Law of Jefferson County, Texas, that in Jefferson County, Texas, Brandon Andre Richards, hereinafter styled the defendant, heretofore on or about August 18th, 2021, did then and there unlawfully and with intent to place Lakendra Nobert, hereinafter styled the complainant, in fear of imminent serious bodily injury, threatened to commit an offense involving violence to the complainant, namely aggravated assault. At the time of the commission of the offense, the defendant and complainant were members of the same family against the peace and dignity of the state.
Mr. Richards, how do you plead? Not guilty, guilty, or no contest? State, you'd like to have an opening statement?
We will waive opening statement.
And defense?
We will waive an opening statement as well, Your Honor.
State, you'd like to call your first witness?
State would like to call Lakendra Norbert.
Lakendra Norbert.
Yes, Your Honor.
State, do you have any other witnesses?
State rest, Your Honor.
Defense?
Your Honor, at this time, the defense would move for a directed verdict of not guilty and a judgment finding the defendant not guilty.
Okay. Court is going to grant an instructed verdict in this case.
Instructed verdict.
Yeah, and Mr. Norbert, that means that you acquitted of these charges. Your attorney will get a copy of your instructed verdict. Once you get a copy of the instructed verdict, you'll be free to go and you have a blessed day.
I can get tomorrow.
Oh, yeah, we'll have to, he has electronic.
Yes, I apologize, Your Honor. That is another issue. So I guess
Okay, yeah,
it's the-
state, you have any objection?
No objection, Your Honor.
Okay, yeah, we'll have to sign an order. Yeah, we have to sign an order. I don't have an order there.
I'll explain that to you.
Yeah, okay, we'll get it out. We'll try to get it out today.
Thank you.
Yeah, matter of fact, yeah, I had an order. It was a condition, it was a condition of his bond. Is that correct? So he's no longer on bond since he's been acquitted. Okay. Yeah, we have an order. We'll get that filed today.
Thank you very much.
Okay.
He doesn't need to sign anything. I guess he needs to call back when the judge is on.
Your Honor, may we approach?
No,
Yeah.
he'll have to get that from the clerk, though.
Yeah, he can get a copy from the county clerk's office. Yeah,
The county order for the dismissal.
no, you're talking about the order for the removal of the other.
Oh, I see.
No, I already have an order. Yeah, it's an oral motion, but I have an order, but I just have to get to it. Sign it.
Okay, can you do that in e-file? Or look up to the e-file system?
Correct.
Okay. And then I can get it to you.
Yeah, and then they'll be able to bring it to whoever the monitor is.
Okay, perfect. Thank you so much.
Okay. Yeah, I got one from Judge Woods. Okay, this is Nicholas Villarreal. Would you please call the name of Nicholas Villarreal? He's on the announcement docket, the second, third, fourth.
Yes.
Second, third, and fourth verse. Court is in session in 3 cases. First case is cause number 322708. The second case is cause number 325280, and the third case is cause number 329976. All 3 cases are styled the state of Texas versus Nicholas Kane Villarreal or Nicholas Villarreal. Is that correct? Mr. Villarreal, how are you doing? How are you doing? That's good. Mr. Villarreal, you're here represented by by your attorney Jason Nix. Attorney Nix, how are you doing?
I'm good, Your Honor. How are you?
I'm doing fine. Thanks for asking. Mr. Nix, what is your announcement in Mr. Villarreal's case?
Your Honor, the state and I need a little bit more time. The case has been transferred through a couple of different prosecutors, and I think we need to track down some of the notes from the prior prosecutor, and I think we're going to get it resolved at the very next setting, Judge.
How much time you need?
30 days.
Standard, okay.
That'll be fine with the state.
Oh, I'm on vacation, I think on the 17th or 11th.
You see July 11th?
7/18, Your Honor.
Oh, 7/18?
Yes, sir.
Okay. Mr. Villarreal, both your cases will be, with all three of your cases will be reset to July 18th of 2022. Your attorney is going to sign for your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Nix, these are your last cases that you have?
Yes, sir. Your
Okay,
Honor.
you'll
Thank
be
you,
free to
Judge.
go as well.
Thank
You have a blessed day. Yeah,
I had one that we didn't get to last time. I didn't realize I had one more.
oh. And who's that?
David Munguia, he's on the trial docket, first stage trial docket.
Oh, yeah. This is cause number 325-304. Case is style of state of Texas versus David Munguia. Munguia. How you doing, Mr. Munguia?
Doing great.
That's good, Mr. Munguia. You're here represented by your attorney Charles Rojas. Attorney Rojas, what's your announcement?
Judge, we've come to an agreement with the state. It's going to be a JP reduction. We'd ask for 30 days to pay that.
Okay. Is this gonna be June 27th? This is a JP reduction on the trial docket. David Munguia.
That's plenty of time.
Yeah.
It's just time to get it in the system downstairs and go down and pay it.
Okay, Mr. Munguia, your case is reset to July 11th, 2022 to give the state time to reduce this case to JP case and give you time to pay it. So stay in contact with your attorney. Your attorney's gonna sign for your reset. Once you get your reset, you'll be free to go and you have a blessed day. Scott Moore. Mr. Kimler, Scott Moore is on Zoom.
Ready.
You can get Mr. Kimler's other cases on the trial docket, Mr. Porter. This is cause number 321-380, case of style of state of Texas versus Scott Moore or Scott Albert Moore. Mr. Moore, how are you doing?
I'm doing well, Your Honor. How are you?
I'm doing fine. Thanks for asking. Mr. Moore, you're here represented by your attorney Wright Kimler. Attorney Kimler, how are you doing?
Same, but a different stage.
Okay. Mr. Kimler, what's your announcement?
Ready?
Okay, now, Mr. Kimler, you're gonna have to reset this case. Give us a reset and keep it on the trial docket.
7/11.
Okay, it's gonna be reset July 11th, 2022. Mr. Moore, your case has been reset to July 11th, 2022. Stay in contact with your attorney. You're free to go and you have a blessed day.
Same to you, Your Honor. Thank you.
Okay. Kiana Ozan,
That one ought to be dismissed. It was a JP reduction. I think she paid the fine.
Kiana Ozan? Is that, he had her here earlier. It's on all of them trial docket.
She paid the JP. It was a JP.
It's Kiana Ozan.
We tried it one time. It's 5-1, not guilty. You get JP reduction.
You have Kiana Ozan? Oh, okay. Okay, we'll go to the next case then. Jose Lopez.
Lopez.
Yes, EMS.
We got to try this one eventually.
I know. It was close before. It's the ENS operator, is that correct? We was going to pick a jury.
Yeah,
I remember
So
that.
is he on the trial docket?
Yeah.
We're ready.
Okay, so that's gonna be July 11th? It's okay. And Mr. Rob Kimler, would you please sign for his reset? Mr. Lopez, once you get your reset from your attorney, you'll be free to go and you have a blessed day. She's gonna give you, you can stand over there, she's gonna give you a reset. Once you get your reset, you'll be free to go. Alexander Reed Burrell.
Ready.
Okay, Mr. Burrell, all right, your case is gonna be, it's gonna be reset to July 11th. Your attorney, Mr. Kimler, is gonna sign for your reset. Once you get your reset, you'll be free to go. Stand on the 4X. Stephanie Arta. Your name is Stephanie Marie Arta?
Yes, sir.
How you doing, Ms. Arta? That's good. And Mr. Kimler, you're nice and ready?
Ready.
Okay, this case is gonna be reset to July 11th, 2022. Your attorney is gonna sign for your reset. Once you get your reset, you'll be free to go and you have a blessed day. Russell Knapp. Hmm? Okay, yeah, but I get it. Is Knapp in here?
This one mine too.
It says Russell Ryan Knapp,
KNEPP.
KNEPP.
Is it on the trial docket?
Yes. Russell Knapp. Mr. Knapp, would you come forward? And Mr. Kimler, you're not ready on this one? Okay. Student State's ready as well. So this case is gonna be reset to July 11th, 2022. Mr. Knapp, you get your reset. Once you get your reset from your attorney, you'll be free to go. You have a blessed day. And Keanu Ozan. Okay, this is cause number 325680, case of style of state of Texas versus Keanu Ozan or Keanu Tashawn Ozan. Ms. Ozan, is that your full name?
That's your name?
Is your name
Keanu
Keanu Ozan? Okay, how are you doing, Ms. Ozan? You doing okay? So? Okay. Now, Ms. Ozan, see, it was a JP reduction. Did she pay the?
You paid the JP fine? You have the receipt?
Is she here?
Yeah, go get her. Huh?
Ask your mama for the receipt.
What? Wait a minute. Wait a minute. Okay, go get it. Where's your mom?
Was it paid? Okay, you could go get your mom. Was it, what JP was it called into? Was it JP1 or? Was it called, Mr. Kimler, was it called in downstairs?
Yes. It's a Beaumont.
Well,
case.
yeah, it wasn't about my case. I think it was in the north end. So it should be JP1. I don't know if she had a receipt. Oh. Okay,
Just go ahead.
that's fine. Y'all can just have a seat.
That's all right.
Okay. Tara McGinnis or McInnes? You want to hold? Okay. Okay.
Oh, okay, well.
Okay, Ms. McInnes, would you please come forward? This is cause number 3277756 and cause number 3277758. Both cases are style of state of Texas versus Tara Ann McInnes. Ms. McInnes, is that your full name?
Yes.
How you doing, Ms. McInnes?
I'm amazing. Thank you. How are you?
I'm doing great. Thanks for asking. Ms. McInnes, you're here represented by your attorney, Attorney Kevin Lane. Attorney Lane, how you doing?
Fine, Your Honor, thank you.
Okay, now, Attorney Lane, what's your announcement?
We're ready, Your Honor.
Your Honor, state is ready also. However, we are still in negotiations. So if we get a reset, we may be able to resolve this.
Okay, because I was saying, well, I had two motions for continuance filed by the state, so. You say ready, kind of threw me off.
Well, yeah. I think we have a lab tech that was unavailable.
Yeah, toxicologist. Okay, you have any objections to the continuance?
I do not.
Okay, so what we'll do, we'll grant the continuances. Hey, Mr. Lane, you can get your reset. Once you get your reset from your attorney, Ms. McInnes, you'll be free to go and you have a blessed day.
Thank you.
There you go. Have any, please, Barry? Not yet, okay.
All right.
You have any more?
Well, Jose's the last one, but she should have that reset.
Yeah, once you get the reset, the receipt, once they verify it, it'll be dismissed. Make sure she doesn't leave. Okay, court is back on the announcement docket. Celso Martinez, who's appearing via Zoom with his attorney, Attorney Charles McIntosh, is also appearing via Zoom. Okay, who's the prosecutor on Celso Martinez? He's on the announcement docket. Okay, this is cause number 330820, case of style of state of Texas versus Celso Martinez. Mr. Martinez, how are you doing?
I'm doing good, Your Honor. How are you?
I'm doing fine. Thanks for asking. Mr. Martinez, you're here. You're appearing on Zoom. Your attorney is also appearing via Zoom. Attorney Charles McIntosh, how are you doing?
Doing well, Judge. Thank you.
Mr. McIntosh, what is your announcement in Mr. Martinez's case?
The court should have a copy of a motion to withdraw that my office filed within the last couple of weeks.
Okay, hold on. They're gonna pull it up. A copy of a motion to withdraw is in clause number 330820. Yes. 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 Mr. McIntosh. The
Yes.
clerk has informed the court that there's not a motion to withdraw in that case.
My apologies then. I thought there would be one.
No, she didn't. No, was it recently filed?
I don't know, Judge. That was something with my, I'll have to ask my staff. But the short of it, Judge, is, and Mr. Martinez, correct me if I'm wrong, but you still have a felony that's pending in another county. And
could you get your motion filed within the week?
yes, Judge, I can get it filed this week.
Okay, I mean, we can reset it. We can reset, well, next week is the holiday, isn't it? Let's do this here. Could we reset it to next Wednesday? Is that? Will you be available for next Wednesday? Mr.
Yes, Judge, I can zoom in next Wednesday.
And Mr. Martinez, would you be able to zoom in as well?
Yes, sir.
Okay, what's that date? Just hold on a minute. What is it? Okay, we're gonna reset this case to June 1st, 2022 at 9 a.m. Mr. Martinez, stay in contact with your attorney and your bondsman. This case will be reset June 1st at 9 a.m. Mr. Martinez, you're free to go and you have a blessed day. And
Thank you.
Mr. McIntosh, is this the only case you have today?
Yes, Judge.
Okay, you're free to go as well and you have a blessed day.
Thank you.
Okay, you're welcome.
So it's on the trial docket now?
Yes, she's on my page 3. Okay, this is cause numbers 329372, cause number 329374.
So
Both
third
cases,
page- Third page of the trial docket, bottom. Yeah.
Yes.
both cases are styled the state of Texas versus Gabrielle D. Fontenot. Ms. Fontenot, is that your full name?
Yes, sir.
Now, Ms. Fontenot, I know that you are representing yourself. You signed a waiver. Is that correct?
Yes, sir.
Now, if I'm not mistaken, the last time you were here, you and the state were talking. You and the DA. Now, the DA that you was talking to at that time is no longer, he's next door, so he's no longer in this court.
Okay.
So do you need some time to, I guess I could give you some time to talk to them there so they can get up to speed on the discussion that you had with the previous DA.
Yes, sir.
Okay? So just have a seat in the gallery and then when we When they're ready for you, they'll call you.
Yes, sir. Thank you, Your Honor.
You're welcome. This is cause number 323981. Case is filed, the state of Texas versus O. Thomas Harvey. Mr. Harvey, is that your full name?
Yes, sir.
How are you doing, Mr. Harvey?
Good, how are you?
I'm doing fine. Thanks for asking. Mr. Harvey, you're here represented by your attorney, Attorney Tom Kelly. Attorney Kelly, how are you doing?
Doing great, Judge. Thank you.
Mr. Kelly, what is your announcement in Mr. Harvey's case?
Your Honor, I've given some documentation to a number of different folks upstairs to review. If you would leave us on this docket, please.
Okay, how much time do we need to reset on your
45 days.
reset? 45? Give us a reset date.
7/18.
Okay, it's gonna be reset to July 18th of 2022. Mr. Harvey, your attorney is gonna sign for your reset. Once he signs for your reset, gives it to you, you'll be free to go and you have a blessed day. Mr.
Thank
Kelly,
you.
Mr. Kelly, is this your last case?
I have one other, Judge, if you wouldn't mind holding for just a minute.
Okay. And Mr. Harvey, once you get your reset, you'll be free to go and you have a blessed day.
You too, bud.
Thank you. I think that's Michael McLeod.
Yes, Your Honor. Yes.
Yeah. I guess you could just have him in here. He said he want to hold on it. I was just gonna have a seat in it.
Is it okay if I do 7:25 for some reason?
Yeah, it's perfect.
You say 7:25?
Yes, sir. Can you do 7:25?
7:25. Okay, let's see, I'll just show you now. Okay, would you call Elar Hernandez? Elar Hernandez on the pretrial conference docket. Eloy Hernandez on the pretrial conference docket.
Judge.
Okay, this is cause number 328826. Case to style of state of Texas versus Eloy Hernandez Jr. Mr. Hernandez, is that your full name?
Yes, sir.
How are you doing, Mr. Hernandez?
Good, a bunch of stuff.
I'm doing fine. Thanks for asking, Mr. Hernandez. You're here represented by your attorney, Attorney Dustin Galmore. Attorney Galmore, how are you doing?
Great, Judge. How are you doing?
I'm doing fine. Thanks for asking. Mr. Galmore, what is your announcement in Mr. Hernandez case?
Judge, if we could hold this temporarily. for a few-
Okay.
Just for a few minutes.
Okay, that's fine. Mr. Hernandez, just have a seat. Mr. Porter, are you ready on Westbury?
Yes, Judge, he's present. He's in the room. And that's,
You need to hold on that, or
No.
Mr. West, okay, Lawrence W. or Westbury, or Lawrence Wayne Westbury? That's still on the, that's on the announcement docket, page 2. Mr. Westbury, your full name is Lawrence W. Westbury or Lawrence Wayne Westbury Jr.?
Lawrence Wayne, Westbury, Jr.
How are you doing, Mr. Westbury?
Good.
That's right. That's fine. Mr. Westbury, you're represented by Attorney Galmore. Attorney Galmore, I see that Mr. Westbury have a felony case that was also set today. Is that correct?
yes, Judge, Mr. Westbury is enrolling in the Veterans Court Program. And I believe his first official class is Thursday. And so we're going to ask to postpone this with the felony. I think that Veterans Court Program will resolve both the misdemeanor and the felony case.
Okay. And state, is that?
No, I'm not opposed, John.
Okay. How much, well, Veterans Court, how much time you gonna need? About 90 days?
I
Because
don't know.
that takes a
when
while.
The felony's going to set it on a day also. I just
Oh.
don't know yet because it's the 252nd, so they don't set
Okay,
it
okay.
Let's
immediately.
do 8/23, and if you find out the new felony date, can you let the court know? please?
Sure will.
8/20, okay, it's gonna be reset to August 23rd of 2022. Mr. Galmore, you can get your reset, sign for the reset, and Mr. Westbury, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Thank you.
You still need,
He's looking at me. I don't know if you can hear me or not. Let me see.
Yes, could you please state your full name?
Christy, Kristi. Last name is Gans, Gans.
Okay, Ms. Gaines, would you please put your mic on mute, and then when we call your case, we'll ask you to take it off of mute.
Yes, sir. Thank you very much, Mr. Judge Holmes. I couldn't get my thing to do. That's why I was using my my neighbor's phone. My phone's going slow.
That's fine. That's fine. Just put your mic on mute, and then we'll call your case back.
Okay, thank you very much.
You're welcome. Now, Ms. Williams, I have here a motion to withdraw that was filed by your attorney, Tom Burbank. And Ms. Williams, you stated that you read the motion. You received a copy of the motion, is that correct?
Yes.
And did you read the motion?
No, I didn't.
Okay, could you hand this to her? You can go ahead and read that motion. Bring me off another time.
Getting off case.
Yeah, Mr. Burbank is filing a motion to get off your case based on, he cited a couple of grounds that is good cause. I think 2A states movement is unable to effectively communicate. Well, he's unable to communicate effectively with you so as to be able to adequately represent you. And second, he states that you have not complied with the terms of his contract between you and him. Now, do you have any objections for Mr. Burbank's withdrawal?
So what would I have to do? Hire another lawyer?
You can, well, first of all, if he is allowed to withdraw from your case, if he's granted the withdrawal, then you'll have three options. Number one, you can hire an attorney. Number two, if you do not have enough money to hire an attorney, you may qualify or you may request for an attorney to be appointed to represent you. Or three, you may represent yourself.
I'm gonna hire an attorney.
Okay, so you don't have any objections to him getting off your case?
No.
Okay, so the court is going to, you can keep that guy. The court is going to grant Mr. Burbank's motion, and Mr. Burbank, you're released from representing Ms. Williams.
Your Honor, if I may.
Yes.
For purposes of the reset, Your Honor, I'd ask that perhaps the case be reset to a non-trial docket
Okay.
to give the state and whoever a new defense counsel may be an opportunity to see if we can't reach an agreed resolution.
Okay.
Thank you.
Ms. Williams, Could we reset our case? How much time do you need to hire another attorney? We can give you 60 days. Would that be sufficient? Okay. What is that date?
7/25.
Okay, so your case is going to be reset to July 25th of 2022. You can get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. All right, thank you. That I signed the order. They still have some that's not signed. Let me go ahead and do the one that's signed. Which one is signed? That's Nathan Renner's case. Next case is Caleb Thomas Quinn. We can cut to the chase. You asking for deferred on the DWI, is that correct?
Yes, Your Honor.
Yes.
The offense date is before September 1st of 2019, which makes him ineligible.
Judge, I did not negotiate that resolution on that.
Yeah.
Or that agreement.
I did, Judge, this morning, tried to switch it from straight probation to.
Yeah, but I mean, the statute say it has to be on or after September 1st of 2019.
Not eligible. There was no deferred.
Yeah, that's.
The day of the allegation.
I knew that. I remember us talking about that a long
Well,
time.
you knew better than me.
I did not, it's been 4 years.
Well, okay, so we can give y'all some more time to talk. Yeah.
Sorry.
Okay.
Sorry.
Yeah, okay.
What happens when I try to be helpful?
All right, y'all can just have a seat. Y'all can have a seat. We can't go forward on that. This is cause number 329154, case of style of state of Texas versus Jamal Fitzgerald Jesse. Mr. Jesse, is that your full name? Mr. Jesse, how are you doing?
Good, how are you?
I'm doing fine. Thanks for asking, Mr. Jesse. You're here represented by your attorney, Mr. West. Mr. West, what's your announcement in Mr. Jesse's case?
We still want to keep it on the trial, Your Honor.
Okay, you gotta give us a reset date.
7:25.
Okay, it's gonna be reset to July 25th of 2022. Mr. Jesse, your attorney is gonna be signing for your reset. Once he signs for your reset, you'll be free to go, and you have a blessed day. And Mr. West, this is your last case? Okay, you'll be free to go as well, and you have a blessed day. You are. Mr. McLeod, in cause number 330834, the state has filed a dismissal. The court just signed your dismissal. Your attorney is going to give you a copy of the dismissal. Once you get your dismissal, you're free to go and you have a blessed day.
Thank you.
Okay,
Thank you,
you're
Your
welcome. Kiana Ozan. Uh-oh, they didn't sign it. You didn't sign the, right here, your name and the board number. Yeah, just pull it on straight.
Just a little on the string.
Yeah.
Didn't want to break it.
All right, thank you. Ms. Ozan, the state has signed a dismissal, and I'm getting ready to sign it. Ms. Ozan, you can get a copy of the dismissal. Once you get the copy, you're free to go and you have a blessed day.
Okay, thank you.
You're welcome. Caleb Thomas Quinn. This is cause number 323-222, case is filed in the state of Texas versus Caleb Thomas Quinn. Mr. Quinn, would you please raise your right hand? Mr. Quinn, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Quinn, you may put your hand down. Mr. Quinn, you're here represented by your attorney. Well, your attorney is of record is attorney James Macon. However, attorney Macon is unable to be here today. And in his place, we have attorney Joel Vasquez. Does Mr. Vasquez have your permission to stand in for your attorney of record, James Macon?
Sir.
Mr. Vasquez, how are you doing?
Good, Your Honor. How about you?
I'm doing fine. Mr. Vasquez, do you waive a record in Mr. Quinn's case?
Yeah, sure.
Mr. Quinn, I have before me a document that is titled Information. This information alleges that on or about October 13 of 2018, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Quinn, do you understand what you've been charged with?
Sir.
And to this charge, Mr. Quinn, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Quinn, I have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, Mr. Quinn, there are a set of initials on a line next to a box that's checked nolo contingere. Did you place your initials on this document? On nolo contingere means no contest. On page 3 of this same document, Mr. Quinn, there is a signature above the line that is titled Defendant. Mr. Quinn, is that your signature? On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, Mr. Quinn, there's a signature above the line that's titled Defendant. Is this your signature? At the top of this document, there are 2 boxes that are checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? Now, Mr. Quinn, I also have before me a document that is titled Discovery Certification. Mr. Quinn, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Quinn, before you signed and initialed all of these documents that I have just mentioned to you, did your attorney, Mr. Vasquez, go over these documents with you? And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Quinn, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibits 1, the misdemeanor plea admonishment. State, you like to also offer State's Exhibit 1 and 2, the probable cause affidavit?
Yes, Your Honor. State offers both states 1 and 2.
Any objections?
No objection, 1 and 2.
No objections of 1 and 2, and the court is going to take judicial notice of the probable cause affidavits in the court's file. Mr. Vasquez, you've advised and counseled Mr. Quinn. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Quinn, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
And Mr. Quinn, your attorney, Mr. Macon, has also advised you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Quinn, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea in this case, Your Honor, the state's recommending confinement in the Jefferson County Jail for a period of 90 days. However, we're asking that the court suspend the imposition of that jail sentence and place the defendant on community supervision for a period of 1 year, order that he perform 40 hours of community service restitution, that he pay a $500 fine, and that in addition to the standard conditions of probation, that he also participate in DWI education and submit to a drug and alcohol assessment.
Mr. Quinn, the state is offering that you serve 90 days in the Jefferson County Jail. However, you would not have to serve 90 days in Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you will be required to pay a fine of $500 plus court costs of $407, which comes to a total of $907. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay the DWI education class and initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay while you are on probation is $160 per month. Mr. Quinn, do you understand the state's offer?
Yes, sir.
And now, Mr. Quinn, will you be able to pay the $160 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service. You'll attend and complete a DWI education class, and you will have a drug and alcohol assessment. Mr. Quinn, you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Quinn, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Quinn, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Quinn, you're going to stand on the X next to your attorney and follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. You're welcome. You have Hernandez judgment.
No, Judge, it's not ready.
Oh, I'm sorry.
Oh, okay.
No, I sent.
No, she has to.
Oh, you doing, okay.
Okay. Court is in session and calls number 328826. Case is styled the state of Texas versus Eloy Hernandez. Mr. Hernandez, is it Eloy Hernandez Jr.?
Yes, sir.
Okay, Mr. Hernandez, would you please raise your right hand? Mr. Hernandez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Hernandez, you may put your hand down. Now, Mr. Hernandez, you're here represented by your attorney, Mr. Dustin Galmore. Attorney Galmore, do you waive a record in Mr. Hernandez's case?
We do, Your Honor.
Mr. Hernandez, I have before me a document that is titled information. This information has been filed by the Jefferson County District Attorney's Office. This information alleges that on November 4th of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Hernandez, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Hernandez, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Sir.
Mr. Hernandez, I have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Hernandez, there are a set of initials on a line next to a box that says check guilty. Mr. Hernandez, did you place your initials on this document?
Yes, sir.
On page 3 of this same document, Mr. Hernandez, there's a signature at the top above the line that's titled Defendant. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, Mr. Hernandez, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
There's one box that's checked at the top of this document. This box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir, I do.
Mr. Hernandez, I also have a document before me that is titled Discovery Certification. Mr. Hernandez, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Hernandez, before you signed and initialed all of these documents that I've just mentioned to you, did your attorney, Mr. Galmore, go over these documents with you?
Yes, sir, he did.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Hernandez, are you a citizen of the United States?
Yes, sir, I am.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. State, you like to offer State's 1?
Yes, sir. State offer State's 1.
Any objections?
No objection.
No objections. State's Exhibit Number 1 will be admitted. Mr. Galmore, you have advised and counseled Mr. Hernandez. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Hernandez, Mr. Galmore has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Galmore, Mr. Hernandez. State. Do we have a plea bargain agreement?
We do, Your Honor.
Okay, let me do this here. Now, let me do this here before I get to that. Mr. Hernandez, the court is going to accept your plea of guilty. The court will also find that you are mentally competent to stand trial. The court will also find that your pleas and waivers were freely and voluntarily given. The court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now, State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea in this case, Your Honor, State's recommending confinement in the Jefferson County Jail for a period of 90 days. However, we're asking that the court suspend the imposition of that jail sentence and place the defendant on community supervision for a period of 1 year. Order that he pay an $800 fine, perform 40 hours community service restitution, and in addition to the standard conditions of probation, that he also participate in a DWI education course, a drug and alcohol assessment, and that any vehicle that he operates or has access to have an interlock device installed.
Okay, Mr. Hernandez, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you will be required to pay a fine of $800. You will be required to pay court costs of $422, which comes to a total of fine and court costs of $1,222. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to pay the Jefferson County DWI education class and initial evaluation fee of $125, and you'll be required to pay an additional $50 should a further evaluation be needed. The total amount that you would have to pay each month while you are on probation is $190. Mr. Hernandez, will you be able to pay the $190?
Yes, sir.
Mr. Hernandez. You will also be required to perform 40 hours of community service, attend and complete a DWI education class, have a drug and alcohol assessment, install a DWI interlock on any device, a DWI interlock device on any vehicle that you own or operate, and you will be required to adhere to the other standard terms and conditions of your probation. Mr. Hernandez, do you understand the state's offer?
Yes, sir, I do.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, I do.
Mr. Hernandez, I'll follow the plea bargain agreement that you've entered into with the state. Mr. Hernandez, you're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day. Mr. Galmore, is this your last case?
It is, except for my one announcement on the trial docket. He's on the way.
Okay, okay, we'll wait for him.
I'll zoom in when he's here.
Okay.
So how long sign this black box? You won't be able to see it. I'm gonna set it wrong. That's it.
Cause number 329730, case of South State of Texas versus Jason Oliver Chandler.
Yes, sir.
All right, Mr. How you doing, Mr. Chandler?
I'm doing well.
Again,
How are you, sir?
are you asking for a reset?
Yes, Your Honor, Mr. Chandler needs to figure out when he can do the 3 days.
Okay, which is, how much time do you need?
30 days.
That's good.
State, do you have any objections?
No objections, Your Honor.
Okay, once you get your reset, what's that reset date? Okay, it's gonna be reset to July 25.
July 18th.
Okay, it's gonna be reset to July 18th of 2022. Mr. Chandler, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Yes, sir. Yes, sir.
And you stand over there and get your reset. Okay.
No, yeah, reset.
Okay, let me, okay. Cause number,
Very quickly, Mr. Coleman,
what is it on?
regarding Mr. Chandler's case.
The one that was just reset?
Yes, Your Honor.
Okay. Mr. Chandler, would you come back?
It's about 3 days.
I just wanted to
Judge, the state made an offer, in an offer that defense counsel relied upon. In this DWI case, it was an offer for probation, and I neglected to include in my offer the 3 days of jail as a condition, because of the nature of this DWI.
Okay.
I just want to inform the court. I mean, I feel like having made that representation and defense counsel relied on that.
Well, but the court sets the conditions of probation.
And I've explained to Mr. Chandler, and it's no fault of Mr. Coleman's, that the 3 days is standard,
Right.
and that the court will order that.
Oh, that's the law.
Okay. I just
Court
wanted
is
to
gonna
get
follow the law.
But this is,
Yeah, the court sets the probation because, once y'all get up and say this is what the plea bargain agreement, the court can set out additional conditions.
yeah, Your Honor, I just wanted to go through it again. I've seen this court do that before, and I've seen it done next door. I just wanted for Mr.
Yeah,
Chandler.
the court is gonna follow the law.
Okay.
Okay.
Thank you, Your Honor.
All right, you're
Thank
welcome.
you, Mr. Coleman.
This is cause number 329080, case of style of state of Texas versus Michael Allen Martindale. Okay, the person that's on Zoom has iPhone. Please put your mic on mute. Thank you. Mr. Martindale, your full name is Michael Allen Martindale, is that correct?
Yes, sir.
How you doing, Mr. Martindale?
Well, not too good, Your Honor.
Okay, well, we hope that you'll be feeling
My
better.
attorney walked right by me out there and looked at me. And
He's on the telephone. Okay, now, Mr. Parker, do we have Mr. Parker on the telephone? Why don't you call him back up then? Okay, just have a seat. Yeah, just have a seat, yes. Okay, do we have anything else? All right, you have a blessed day. Okay, Jorge Gonzalez. Mr. Galmore. I think you just put your mic on mute. Take your mic off of mute, Mr. Galmore. Yeah, Mr. Galmore, your mic is on mute. Okay, Mr. Galmore, how are you doing? We can't hear you.
Hey, Judge, I'm sorry.
Okay, this is cause number 325296, case of style of state of Texas versus Jorge Gonzalez. Mr. Gonzalez, you're represented by Mr. Dustin Galmore. Mr. Galmore, what's your announcement in Mr. Gonzalez's case?
Judge, we do not have an agreement that it's still a trial.
Okay, give us a date.
7/25.
Okay, this case is going to be reset to July 25th of 2022. Mr. Gonzalez, you can stand over on the far exit, get your reset. Once you get your reset, you'll be free to go. You have a blessed day. And Mr. Galmore, I think this is your last case. Is that correct?
It is. Thank you very much, Your Honor.
All right, you're free to go and you have a blessed day.
You too. Bye-bye.
All right.
You know what the blue double doors are? Yes.
Okay, we have Christy Gans. Your mic is on mute.
Yes, sir. I'm here. Thank you. I'm sorry, Your Honor.
Okay, that's fine. Ms. Gans, you may have to get back in contact with your attorney, Mr. Buddy Reynolds. Nathan Reynolds.
Yes,
He
sir.
was here. He probably contacted you. You
Just now.
asked him-
Just now. I was on the other phone. Yes, sir. He's just contacted with me. Maybe.
Okay. So is he gonna get back on Zoom?
Because actually I was, like I told you before, I was using my neighbor phone because my phone was downloaded stolen. So he just called me. Do you want me to call him back and let him?
Oh, there he is.
I can actually call back on my.
No. He just popped. He's on Zoom now.
Okay.
Mr. Reynolds.
Yes, sir, Judge.
Okay, we have, this is cause number 328850. We have Christy Faye Gans, who is also appearing via Zoom. Ms. Gans, how are you doing?
I'm doing fine. How about you, Your Honor?
I'm doing fine as well. And Mr. Reynolds, again, how are you doing?
I'm doing well, Judge.
Okay, now this case is on the trial act. What is your announcement, Mr. Reynolds?
Judge, I had previously filed a vacation letter and I will be unavailable to try this case tomorrow. I do believe it will be worked out if the court can put it on another trial docket or an announcement docket.
Which one you prefer?
Announcement, Judge.
Announcement? You have any objections?
No.
Okay, give us an announcement date. Just hold on. How much time you need? About what, 60 days?
30 days would be fine,
30,
Judge.
okay, 30. Okay, to be reset to July 18th of 2022. Ms. Gans, your attorney your attorney will be given notice of your reset. Stay in contact with your attorney. Your case have been reset till July 18th of 2022. Thanks for being patient with us. You're free to go and you have a blessed day. And Mr. Reynolds, I think this is your last case as well. So you're free to go as well and you have a blessed day. Your reset will be sent to you.
Yes, sir. Thank you very much, Judge.
Okay, you're welcome.
Thank you.
You're welcome. Okay, then the last person that's on Zoom, would you please state your name again?
DeMonica Hadnot.
Hadnot. Oh, that was Mr. Burbank, right?
Yes, sir.
Okay, hold on. Okay, your attorney was here earlier. Oh, yeah. Okay. That's the one he said that they had got confused. Now, Miss Hadnot, your attorney, Mr. Burbank was here. He stated that you were supposed to pay a JP reduction, but y'all didn't know what court to pay it to. And so we'll give you, your case is gonna, he requested that your case be reset to give you time so that you can pay it so you can pay the JP reduction.
Okay, so do I have to come back to court or no?
Okay, well, you have to, if you pay a JP reduction, now your case is gonna be reset. You have to go pay it at the right Justice of Peace Court and get that receipt to your attorney. And then your attorney will bring a copy of that receipt to the DA's office, and the DA's office will dismiss the case. Now, if that's not done prior to your court date, then you have to appear on your court date. Do you understand?
Okay, could you explain further on like why do I have to come to court again if I pay the little fine thing?
You would have to come to court if you haven't given it to your attorney and he has not given it to the state in the case, and the case hasn't been dismissed on that court date. If it has been if you give it to your attorney, if you pay it, give it to your attorney gets it to the DA's office, the DA's office is going to dismiss the case before the court date, which means you won't have to come. So as soon as you can pay it and get it to your attorney, and then that would give the state adequate time to dismiss the case before your court date, so you will not have to come to court on that day. But if you don't pay it by the court date, then you will have to come to court.
Yes, sir.
Okay.
Yes,
Now, how much time are you going to need to pay this? Do we know how much it is? Do you know how much you have to pay, Ms. Hadnot?
Well, Mr. Burbank told me it was $100. So I had went to the place with the $100, like willing to pay it. My card had got locked, and when I got there, she told me it was gonna be additional $140. I was never like told anything about paying $240, so I only paid $100. So I guess all I need is till like the second week of June. So like the 10th of June, I'll have it paid off.
Give us that June 27 date. Can we give it a June 27 date? Okay. Okay, your case is going to be reset to June 27.
Yes, sir.
So if you pay it by June the 10th, get that receipt to your attorney so you can get it to the DA's office, so you would not have to come on June 27. Okay?
Okay. Yes, sir.
All right. And just make sure, if you get close to June 27, make sure your attorney has already given a receipt to the DA to make sure you won't have to come. Okay?
Yes, sir.
All right, you're free to go. Case is reset to June 27, 2022, and you have a blessed day.
All right, you too.
Thank you. Joshua Shea Peavy. Oh, let me see. I think that's, hold on a minute. Let me do this here. Okay. Court is in session in clause number 331-268. Case of style of state of Texas versus Joshua Shea Peavy. Mr. Peavy, would you please raise your right hand? Mr. Peavy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Peavy, you may put your hand down. How are you doing, Mr. Peavy?
Good.
That's good. Mr. Peavy, you're represented in your case, at least your attorney of record is attorney James Macon. Mr. Macon is unable to be here today. Standing in for Mr. Macon is attorney Joel Vasquez. Mr. Peavy, does attorney Vasquez have your permission to stand in for attorney James Macon?
No, sir.
Mr. Vasquez, do you waive a record in Mr. Peavy's case?
Excuse me, yes,
Mr. Peavy, you've been sworn in. Now, Mr. Peavy, I have before me a document that is titled information. This information alleges that on or about September 6th of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of boating while intoxicated. Mr. Peavy, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Peavy, how do you plead? Guilty, not guilty, and no contest?
No contest.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, Mr. Peavy, I have before me a document that is titled Misdemeanor Plea Admonishments. I'm gonna have to change this here. Okay. Mr. Vasquez, I noticed they didn't have a box for boating while intoxicated, so it has the same punishment range as the driving while intoxicated, so I just changed the name from driving while intoxicated to boating while intoxicated, so you could check the appropriate box. I noticed you.
Thank you, Judge.
Okay.
I didn't know. Same thing, we just changed driving.
Mr. Peavy, I have before me a document that is titled Misdemeanor Plea Admonishment. You'll notice my initials on the side, and you notice we strike through the word that said driving while intoxicated and change it to boating while intoxicated, which has the same punishment range. Now, do you recognize this document?
Yes, sir.
On page 2 of the same document, Mr. Peavy, there are a set of initials on a line next to a box that's checked nolo contendere, which means no contest. Mr. Peavy, did you place your initials on this document?
Yes, sir.
On the next document, Mr. Peavy, that is titled, well, on the same document, on the next page, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
Okay. And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I also have a document before me, Mr. Peavy, that is titled Discovery Certification. Do you recognize this document? Once you get that to him, you could let him take a look at it. Okay. Now, Mr. Peavy, do you recognize the discovery certification?
Yes, sir.
And is this your signature on the line that is titled Defendant? Now, Mr. Peavy, prior to signing and initialing all of these documents that I've just mentioned to you, did your attorney, Mr. Joel Vasquez, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Peavy, are you a citizen of the United States? Mr. State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1 and State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections?
No objections to 1 and 2. Your Honor.
No objections. State's Exhibits 1 and 2 will be admitted. The court will take judicial notice of State's Exhibit number 2, which is in the court's file. Mr. Vasquez, you've advised and counseled Mr. Peavy. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Peavy, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Okay, Mr. Peavy, you also been advised by your attorney, Mr. James Macon. Are you satisfied with Mr. Macon's representation?
I don't believe I only spoke to him once, but sure. Yes, sir.
Now, has he provided full, effective, and competent legal representation?
Yes, yes, sir.
Okay, Mr. Peavy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's a 1-year deferred, $1,000 fine, 60 hours community service, DWI classes, drug and alcohol assessment, and no operating a boat while on probation.
Okay, Mr. Peavy. The state is offering that you serve 1 year deferred adjudicated probation. Well, let me do this here. Now, Mr. Peavy. Okay, now, Mr. Peavy, do you hold a commercial driver's license or commercial driver's license permit?
I did.
You say you did or you do?
also have a handgun license.
Okay, my question, now, do you have a commercial driver's license?
No, it's reduced down. Whenever I got another driver's license after this, it's.
So you're saying that you no longer have
Yes, sir.
the commercial driver's
Here
license?
it is. Correct.
Is that correct?
Yes, sir.
All right. And the reason why I was asking, because if you had a commercial driver's license, pursuant to Article 42A 102B1, B1, section B1, 1B, yeah, you would have been eligible to get deferred adjudicated probation. All right. And state the BAC, or the blood alcohol concentration level, it's my understanding was 0.138.
1.3, Judge.
1.3. Okay, so that's below the 1.15. So based on that, Mr. Peavy, you do meet the eligibility requirements for deferred adjudicated probation in this case. Now, Mr. Peavy, the state is offering that you serve 1 year deferred adjudicated probation. And just for the record, this case occurred on or after September 1 of 2019. Now, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $422. You'll be required to pay a probation fee of $60 each month, a year analysis fee of $15 each month. You'll be required to pay the Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. The total monthly installments, that is a total amount that you'll be required to pay each month while you're on probation, is $205. Mr. Peavy, will you be able to pay the $205?
Yes, sir.
You'll also be required to perform 60 hours of community service. I didn't hear her say that. Was part of the agreement for him to install a DWI interlock device? I didn't hear you say that. So I wrote down what she.
No.
No.
Was it on the plea papers or something?
No, Your Honor.
Oh, okay. She's gonna check. I heard one thing and I'm looking at something else. Oh, let me take a look. Oh. Oh. Let's not check. Take a look. Yeah. Yeah. Yeah, I didn't see it checked off on there.
Is this the one?
This is PV.
This isn't the one that he did.
No.
No, you don't have to do it. It's not good. That's fine. Everything else is.
Everything, okay, I just have to start through that, okay. Okay, now let me do this here. Hold on a minute, that may be it's deferred, so that's automatic, right? That's automatic, yeah. That's a condition of deferred, DWI, whatever, yeah, that's a condition. Yeah, matter of fact, that's under. Yeah. Yeah, share require. Now that y'all need to, y'all need to have a reset. Y'all need to.
No, Judge, I told Mr. Peavy this matter would come up, and I told him I would urge the court after a drug and alcohol assessment that the court under 42A 408E2 may waive the interlock if it finds it's best for the public and feels that the interlock is not necessary in Mr. Peavy's case.
I think what the statute basically says is that a judge may waive the initial interlock requirement under section E1 for the defendant if, based on a controlled substance and alcohol evaluation of the defendant, the judge determines and enters in the record that the restricting the defendant to the use of ignition interlock is not necessary for the safety of the community.
Yes.
So, I mean, there's been no controlled substance and alcohol evaluation as I mean, so.
Would that not be done in probation, Your Honor?
It
The
is,
drug and alcohol assessment?
I think this is a condition precedent. Yeah, this occurs before. It doesn't, it's not after the fact, it's before the fact. That's what the judge has to evaluate to make that determination. And right now, we don't have anything to evaluate.
But once it's done, can the case be reset a month or 2 months to come back to court, and the court can find out, determine whether or not it wants to waive the condition of the interlock?
What are you saying? Talking about, you talking about resetting punishment? Or what are you talking? I mean, you said coming back later.
Well, once
The way I read it, I think that has to occur before.
Oh, well.
So it's not, yeah, it's not yeah, I mean, you don't, once he's punished, you can't come back and change punishment. Yeah, the punishment can't be changed once it's, you can't come back and change the punishment.
The court cannot find, and I don't know.
I'm just saying that the way I read it, it seemed like that has to happen before. It seemed like somebody has to do a controlled substance and alcohol evaluation.
Could the court not always modify conditions of probation if the court deems it in the best interest? Just throwing it out there.
I'm thinking when we looking at if a condition of an interlock condition is installed, I mean is required. I mean, I don't think there's a basis in the code that gives the court the option to come back, because what happens is a court can allow a person to have an interlock up to 50% of the time of the probation. I mean, no less than 50% of the time of the probation.
Correct.
And that's the provision, but that provision doesn't say he can come back. If you give him a year, you can come back and put him on 50% of the time. Yeah. I mean, I hadn't seen a case on that. In fact, I think this has come up before, and there's no, well, nobody's been able to find a case on it. So I'm thinking of the abundance of caution. I mean, if that's what y'all want to do, we can hold off on the plea. He can get this controlled substance and alcohol evaluation, and then come back and do it. And then the court will have something to look at, and the court can make a decision at that time.
Who would do the evaluation? And if it's not the probation department, would it be at the defendant's expense?
Probably. Yeah, I mean, there are places out here in the community that can do that.
Yeah, I'll definitely do that to keep them.
I mean, he just wants to take a shot to see, well, you know, have the court to look at it, and then we'll be able to make that determination.
Could we reset then, Your Honor?
Yeah, we can reset it. Okay, at this time, we won't go along with the plea bargain agreement. We just reset the case. How much time? Well, y'all gonna have to figure out. We'll reset it 60 days.
Thank you, Judge. I'm misinformed, Mr. Peavy. I thought that was done. The probation is something the court looked at.
No, yeah, I think probation does stuff once a person is on probation. Yeah, I mean, this is not. Yeah, I mean, the way I'm reading it. Yeah, that's the way I'm reading it. It hadn't come up before.
I thought we had dealt with that before, Your Honor. No?
Not here.
Not your
You
court?
could have been in another court, but not here.
You don't have to pay 2 court fees?
No.
Yeah, what's your reset?
You're gonna have to sign all of your judgments first before she can reset it.
Oh, I signed all these judgments?
You're
Okay,
gonna sign all your judgments first.
okay,
If you don't, it'll remove everything.
okay. Oh, you say all the judgments?
All
Okay,
the judgments that are made will have to be signed first before you can.
okay, I'm gonna omit this here.
MIS is out for lunch, so there's nobody.
Okay, okay. Okay.
Very good.
Okay, we'll be in recess. Now, Ms. Fontenot. Now, Ms. Fontenot, you have two cases. First case is cause number 329-372. Second case is cause number 329-374. Both cases are on the trial docket. Both cases on the trial docket. And previously, Ms. Fontenot, you signed a waiver indicating to the court that you wanted to waive your right to an attorney and represent yourself. Is that correct?
Yes, sir.
Now, Ms. Fontenot, I'm looking at another document that you just recently signed. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. And on this document, Ms. Fontenot, do you recognize this document?
Yes, sir. Yes, indeed.
Yeah, and is this your signature on this document?
Yes, sir.
And are these your initials on the line stating that I want to apply for court-appointed counsel?
Yes, sir.
Now, Ms. Fontenot, I also have a document that's titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And Ms. Fontenot, on page 2 of the same document, is this your signature on the line that's titled Defendant Signature?
Yes, sir.
Now, Ms. Fontenot, before you signed and initialed these documents that I've just showed you,
Yes, sir.
did you read the documents?
Yes, sir, I did.
And did you understand what you read?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, it is.
Now, Ms. Fontenot, based on your answers in this document, in the Affidavit of Indigence, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you, in this case, Ms. Fontenot, is attorney Terrence Allison. Okay, and that's Allison.
Judge, I'm sorry, on that case, the reset, is it being reset to a non-trial setting?
Which one?
The Ms. Fontenot's case, is it being reset?
No, it's
to
not gonna be a trial. She just got an attorney.
Well,
appointed.
it's on the trial docket now.
I know.
I just want to make sure it's not getting reset to another trial docket until,
Yeah,
okay.
no,
Until we had a chance to get with that new attorney.
right. Okay, now, Ms. Fontenot, your case is going to be reset to what is called the announcement docket. That'll give time for your attorney, who has just been appointed, to interview you and do what is called discovery on the case, and negotiate with the district attorney's office as well. Could you check and see if we have bond conditions? I don't see it on the. Okay, we need to give her some bond conditions. Could you reach in that blue folder? Could you reach in that blue folder? This is, Ms. Fontenot, we're gonna give you some bond conditions. Let me see. Agree to. Copy this one. Get this copy to her. I'll go to see why you come in and copy. Now, Ms. Fontenot, you've just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay. And it reads, following the arrest and accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.4482 and C2. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply because it only applies in DWI cases. Your case is not a DWI case. Now, Ms. Fontenot, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, you can be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, Ms. Fontenot, you can keep that the bond conditions for your records. You're gonna stand on the far X in front of our court coordinator. Once she finishes, then your case will be, once you give you your reset, your case will be reset to that date and you'll be free to go. You have a blessed day. Yeah, thank you. Mr. Vasquez, you have another case?
I do, Your Honor. If the court would,
Which, would you call that name?
no, if the court would give us till 4 p.m. today, Your Honor, he knows to be here.
State, do you have any objections?
Yes, Your Honor.
Okay.
And last time he was in the hospital and he provided documentation.
Okay, so we give you the 4 p.m. So what I'll do right now, we'll call it and we'll just hold off on the bond forfeiture. If he doesn't contact us by 4 p.m., then the bond forfeiture go through. Okay, so.
If a finding, Judge, what do we do?
You can contact the court. We can get on Zoom or we can do it by telephone. Now, this is cause number 330452. Case is filed in the state of Texas versus Mark Johnson or Mark Clinton Johnson. Mark Johnson was scheduled to be in court on today's date of May 23rd of 2022 at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Mark Johnson at the courthouse door. Mark Johnson did not answer. Mark Johnson has not appeared in court since the court has been in session. The time now is 12:22 p.m. on today's date. The bailiff just called the name of Mark Johnson again. Mark Johnson did not answer. However, Mark Johnson's attorney, Mr. Joe Vasquez, is present in court. He informed the court, he requested the court to give him till 4 p.m. to contact have Mr. Johnson contact the court. State, you have any objections?
No objection, Judge. The state moves for a bond forfeiture provided or conditioned upon the fact that the defendant, if he makes contact with court before 4 p.m. this afternoon, the state will withdraw its motion.
Okay, that motion will be granted.
Thank you, Mr. Coleman.
Okay, and if you do not make contact by 4 p.m., then Mark Johnson's bond will be forfeited and warrant shall be issued for his arrest. All right. And Mr. Vasquez, I think this is your last case. You're free to go and you have a blessed day.
Judge, may I share I got a really bad voting while intoxicated joke first?